is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, welcome back. Carl Rominger here, 540-058. I'm going to answer a question about constables and body warrants here in a second that I got on Facebook. Oh, boy. Okay, that last guy, why was I yelling at him? Well, first of all, he's so clever. He's got his wallet wrapped up with a ACLU case to show the police officer how he's not going to talk and he wants his attorney. And then what does he do? He talks the whole time and talks himself right into a DUI, apparently. Sounds like his night of fun turned into a night of pain. Now, he's guilty because, and guilt's actually a judicial determination, so he's right. He's technically not guilty. He's presumed innocent until he's successfully prosecuted. But he committed the act of DUI. It's just a question of whether the government's going to get a chance to prove it or not, or whether their evidence and their collection of the evidence was tainted, and therefore under the exclusionary rule, it doesn't warrant being brought into court. So I want you all to think about this for a minute. The Supreme Court of the United States has said, and the Supreme Court of Pennsylvania and other places, have said, well, if you collect evidence, you have to do it in a constitutional manner or you can't use it. Now, there are things called the good faith exception. There are all kinds of caveats to it because the idea is we're recognizing that we might let guilty people go by hamstringing the government's ability to enter the evidence. The courts created these rules, these exclusionary rules, because they discovered that law enforcement can't always be trusted to play by the rules. And so they said, how do you make somebody play by the rules? You have to punish them if they don't. And the easiest way is, if your job is to enforce the laws, you will not be able to enforce the laws if you don't follow the law. And that's the exclusionary rule. So just because he has a constitutional protection and perhaps his Fourth Amendment rights or Article 1, Section A of the Pennsylvania Constitution rights were violated by the collection of this evidence, and it was the fruit of the poisonous tree, as he was calling it, doesn't mean he wasn't guilty of, or let's say he didn't commit the act of DUI, because it is illegal in Pennsylvania to have the metabolite of marijuana in you. So you may now travel to Colorado, legally smoke pot on Tuesday, fly back on Wednesday, not drive for a week, get in your car, and you are guilty of a DUI, even though you're under the influence of nothing, because the Pennsylvania legislature has said that mere nanograms of metabolite make you DUI. So the next time you hear somebody had a DUI, just remember they might have not done anything except perhaps drive at a time when they had trace amounts of a metabolite of marijuana in their blood, or maybe took too much of their prescription medication, or drank too much, or had metabolites of some other drug in their system, or accidentally ate a hashish brownie without knowing it, because it's strict liability, baby. And if you didn't know it, you still can't drive for a month. So it actually led one judge here in Pennsylvania to speculate a few years back. Somebody put marijuana in a Burger King hamburger that was fed to some police officers at the drive-thru. And it led that judge to speculate, could those officers legally drive now for a month after somebody spiked their burger with marijuana? Not enough to get them high, but enough to put the metabolite in their system at levels which would forbid them from driving. Anyway, I can go on and on. So anyhow, I got this question from my friend Jason, and he says, can a constable enter your house, basically, to serve an arrest warrant? And the answer is yes. In United States Supreme Court, Payton v. New York, Payton v. New York, they found that an arrest warrant founded on probable cause implicitly carries with it the limited authority to enter a dwelling which the suspect lives when there's reason to believe the suspect is within. So yes, they can come to your house and arrest you. The other question then becomes, if you just know the person's in the house. So we won't answer that today. That's for another day. 540-0580. Carol, you're on the air. Hey, Carol.
Carol?
Yep.
Yes. Hi, Carl. I have a quick gun question for you. I have signed up for a basic handgun course at the local sportsman club because I have a new gun. I haven't shot for a while, and I think they require it to use the range and so forth. And that's all well and good. but I was going to sign up for another class next month, an NRA class, a self-defense in the home course.
Right.
And I told my son about it. He lives in New Jersey, and he said, Mom, don't do it. And I said, why not? And he said, because you're just raising your level of liability. If something were to happen and you panicked, like somebody broke into the house and you felt very threatened, then let's say I shot somebody, and then if I were put on the spot, I could be asked, well, weren't you taught A, B, C, and D, and did you do this, and did you try pepper spray, and did you...
Well,
you know what I mean? So now I'm afraid to take the course. And what say you, Carl?
I say I would take the course. Here's the answer. If you had to shoot somebody, the last of your worries is going to be civil liability, because it doesn't really matter. You're either going to be found liable or not liable. Whether or not you had training, I think the training goes the opposite way. See, because I would tell your son, under that logic, then bars should never train bartenders to recognize drunks, because then when somebody is drunk, they're going to have a worse case.
Right, okay.
I mean, you can run that logic in either direction. Here's the other answer. You probably have homeowners insurance or renter's insurance, and they would cover your cost of defense on a case like that.
Oh, really?
Yes.
Didn't know that.
And number two, in the case that the dead burglar or half-dead burglar gets a $18.6 million judgment against you, we're just going to walk you through a personal bankruptcy, and you'll be able to keep your retirement anyhow. So I wouldn't fret about it too much, and frankly, it's going to be better for us as gun owners if everybody's better trained, because that just pushes holes in the arguments of those who want to take your guns.
Right. Well, that was my reasoning behind it, and I thought, there may be things that I should be doing that I'm not doing, but I just didn't, it did make me pause when he said you're going to really have your feet to the fire. It reminds me
of the conventional. I have all these farmers out there and landowners who'll say, "Oh, you can't fish in I can't let anybody fish in my pond, because if I give them permission, I'm opening myself up to liability." And the answer is a pond's a pond's a pond. And if you have no trespassing signs up, your duty to me as a trespasser is the same as your duty to me as a social guest or an outdoorsman, which is to warn against known hazards. If I'm a 7-year-old kid, your duty is the same. It's an attractive nuisance whether I'm trespassing or not. So giving people permission to fish does not increase your liability in any way, shape, or form.
Oh, okay.
But for some reason, there's this myth out there, and people always worry about that. And I feel the same way about. I understand what your son's saying is, yeah, you knew better. So now we can kind of compare you to this person who knew better. But the answer is it's still a reasonable person standard, and it's not anything different than that. And your heightened
I wouldn't be it's not going to make me a professional.
Right, you're not a boxer.
Right, and I'm still a 65-year-old woman that lives alone.
These fists are licensed in the state of Nevada, right? So they're deadly weapons.
Yeah, so, I'm still subject to human emotion, and it isn't like I'm a professional arms enforcement officer. Okay,
right.
Well, I'm glad that you clarified that, Carl, for me, because I almost didn't send in the money for the course, and I thought, maybe I better not.
I would do it.
I'm glad that I called you. Thank you so much.
All right, take care.
Thanks, Carl. Bye.
540-0580. Somebody's on the line, but I don't see a name. What's the number 3 again? We got to get this thing fixed. Tammy? Tammy?
Yes, I'm here.
You're on the air.
Hi. I had a question. I have a 16-year-old son. He was he one night went out with his friends to one of their other friends' house. Supposedly one of the other boys had sold an Xbox and an iPad from this boy's house. It was his friend. So my son was just kind of tagging along. He didn't even know the kid.
Mm-hmm.
So they charged my son and this boy, and then there was another boy that was also tagging along with theft, conspiracy, and receiving stolen property. So the police had contacted me. We never went in and talked to the police because I wanted to get a lawyer before,
mm-hmm.
to go. And so they sent him the charges in the mail. And so I had I had a question. I had heard that they do have a first-time juvenile deferment program or something.
Okay.
That if he does like 6 months probation, he doesn't plead guilty or not guilty. He just does the probation and it'll wipe his record clear. Or we could fight it and then, he'll have the record for the rest of his life if we lose.
Well, the short answer is depending on the... I'm going to go to break, and we come back, we're going to answer this, okay?
Okay.
Right, hold on. 540-0580, Carl Rominger answering your legal questions throughout the week. Go to RomingerLaw.com or call us at 717-241-6070. See you after the break. All righty. Tammy, we're talking about the age-old dilemma of do I fight it or do I take the result that's going to guarantee it doesn't show up on my record, right?
Yeah.
Now, as a cautious lawyer, I like the second alternative generally, okay? I also run into this situation. Kids quite often, or even adults quite often, will deny any knowledge of criminal liability. But sorting that out is sometimes difficult because, you as mom are going to hear, no, I didn't know anybody was taking anything. I really wasn't sure what was going on. I really thought it belonged to so-and-so. And maybe that's all true, but that can all come crashing down. So when I do the overlays in my mind and I go, okay, I have to assume that my kid is not 100% accurate, even though I want to, and even if I believe them to be, I have to accept that there's a possibility that there's some danger of information coming to light at some point, which shows I'm not getting the whole picture, okay?
Yeah.
You have to put that, and I don't care how much you love your kid, how much your kid's never had a history of anything. You just have to assume, and this is just a way to think about the problem. It's not a way to think about your kid, okay? But you just in the problem, you have to assume that you may not have 100% of the truth of the situation. So your kid may be guilty or more innocent than you believe. It could be either one. But the point is you don't have 100% certainty. Then when you take the other overlay and you're given a choice and you have 100% certainty that we know permanent record and that it will be expunged, you kind of have to look at the two and go, okay, now if I want to fight it, I don't have a guaranteed result there. Plus, I don't know 100% what all the information is going to be. It would be much different if it was a juvenile felony and it was going to stick on your kid's record until 27, okay?
Yeah.
So my advice is usually to get out of there with your skin intact rather than go down swinging.
Yeah.
All right?
Okay. That's more or less what I was thinking. Why take the chance and... then he has a record.
But be fair to your kid. And here's how here's my conversation, right? Let's say your kid's name is Bob Durgan, right? I'd set him down and I'd say, Bob, listen, I love you and I generally believe you and I really do think what you're telling me is what happened. But as a parent, I recognize that sometimes, people don't want to own up to everything they've done. And I'm not questioning you. I'm just saying I have to go through this logic in my head. And so this is a result that if you didn't do anything wrong, what we need to learn from this is don't hang out with the kids who do things wrong.
Yeah.
On the other hand, if you did do something wrong, then you should learn from it. So either way, it works out for the better, and it's going to stink. And I'll help you out with the financial portion of it, but the community service is all yours.
Yeah. So what I'm asking is they do have a first-time deferment program for juveniles?
They quite often do. It's a consent decree, and then it's a lot of times you avoid an adjudication. So yeah, there's ways of doing it that will result in it just being eventually dismissed.
Okay.
But you should use a good juvenile attorney or juvenile public defender. What county are we in?
It was Gary Township, so it's Dauphin County.
Dauphin County has and Cumberland County as well, both have wonderful juvenile systems, and they have great judges for that system. Okay. So it's not like, you like to say, some people go, oh, you always say the judges are good. I'm like, no, I wouldn't have said that about Scranton a couple of years ago.
Yeah. Okay.
All right.
Thank you.
Good luck.
All right, thanks.
540-0580. Carl, you're on with Carl.
Yeah, hi, Carl. Too many Carls here.
Okay.
Let me set up a scenario.
Okay.
Suppose I'm walking through town here in Pennsylvania, any little town.
Many towns in Pennsylvania.
What'd you say?
There are many towns in Pennsylvania. Many.
Yes, I know. But it's in Pennsylvania. It's a Pennsylvania law. Okay. So I'm walking through town.
Can I stop you for a minute? Let's call it the town of Dickinson, because when I went to the Dickinson Law School, everything happened in the town of fictional town of Dickinson.
Is that what they do in that law school?
Yes.
Okay. So I'm walking through the town of Dickinson, and I'm walking through the public square area.
Okay.
Okay. And I happened to see, I mean, I know the public square is owned by the town of Dickinson. That's
Correct.
been confirmed. And I happened to see, let's say it's a lawnmower or a statue or something there.
Okay.
And it's not there all the time, but I just noticed it's there. And so I go, that's interesting, it's there. And then, the next day or two, I happen to pass by again, and it's still there.
Okay.
And a couple of days more, it's still there. And then, so I contact the town and I say, did you allow that object to be there?
Right.
And they say, no, we don't have any mechanism for permitting it. We have no record of whose it is.
Right.
Okay. Now, am I going to be committing theft if I either take it for my own use,
mm-hmm.
or throw it out,
okay.
or turn it in? I don't know if they have a lost and found department
yeah.
or the police. What kind of trouble could I get into?
The worst trouble you can get in, you can be found guilty of theft of mislaid property.
But it says. But here's the deal. I looked up that law,
right?
And it says that's a person who comes into control of property of another that he knows to have been lost, mislaid, or delivered under a mistake as to whatever. Okay. And if he fails to take reasonable measures to restore the property to a person entitled to have it. I mean, so suppose I see this thing there, and it's just sort of annoying
right.
there, okay? And I pick it up, and I take it to the town hall of Dickinson. I say, I found this in the public square, okay? Is that enough? And then it's up to them to say, okay, well, we don't know anything about it. Have I fulfilled my duty?
Well, that's the question. That's the question, because it says, let's see, if with the intended deprivation, he fails to take reasonable measures, okay? And these are the weasel words in the law.
Right.
What is reasonable? So under the circumstance, okay?
Right.
Under the circumstance, if it's a wallet with the guy's name in it, I think reasonable measure is to find.
Oh no, this would be a situation.
Oh yeah, no. I just want to talk about the word reasonable here. So I'm just changing them around a little bit.
Okay, gotcha.
So if it's a wallet with a guy's name in it, right?
Right.
Or the statute says, such and such a Dickinson school class of 1982.
Sure.
You would have somebody specific to contact and check out and see if it's really theirs or not.
Right.
And a lot of police departments, of course, will accept lost items and hold them to see if anybody claims them as well.
Okay.
And so you can do that as well. Take it to the police department and say, I found this, and see if anybody claims it. And after a reasonable period of time, they'll release it back to you, okay?
Right, right.
Because, first of all, the statute does not cover abandoned property, right?
Apparently not.
Right, it doesn't.
How do you know whether it's abandoned?
Well, that's the factual question.
Right.
And so here's the question. A cigarette butt is likely to be abandoned.
Okay.
A gold coin is likely to be lost. Okay? But somewhere in between, in the entire spectrum of things, one man's cigarette butt is another man's cigarette, I guess.
Okay.
Somewhere in between that spectrum of things, it's more or less likely that it was lost or abandoned, right?
Right.
How long it's been there. If you've been walking by the thing. So I'll give you an example. I had a client, and he got a phone call. He was a salvage guy, and he got a phone call from a guy who had a shop where somebody had left a car there for 5 years. And, of course, they didn't go through the proper salvage mechanisms that they needed to do. But the guy's like, this car's been here for 5 years. There's a $1,000 repair bill on it. It's worthless. Its tires are flat. It's rusted through, blah, 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 blah. I'll sell it to you for a couple $100. The day after they did that, right, the state police are there. And they're like, someone reported her car stolen. And the guy's like, well, that's strange. I never heard from her for 5 years. Well, apparently she was driving by it every day on her way to work. Never intending to pay her bill, right? But the day that it disappeared, she decided that it was stolen. And, of course, with titled property, it's a little bit different because there's a VIN number and they had to go through some procedures. It got all smoothed out because, as the state police officer wisely observed, just give her the money from the salvage yard for the thing and move on. And that's what we're going to do to call it even because... But there's a question, right? So in one person's mind, it's clearly abandoned at this point. In the other person's mind, they're just intending to pick it up any day now. Just took them 5 years to get around to it, and they still haven't until it disappears. Right. So that's another characteristic. So what question,
Well, I mean, suppose this was a nativity scene.
Right.
Okay.
Well, is it Christmas time, and how far past New Year's is it?
Yeah. Well, but it's a nativity scene, and say the town says, we don't know who owns it.
Right.
It appears here, and we don't know who owns it. In fact, suppose they even put a little sign up in front of it that said, "The town of Dickinson, it does not own this display and does not endorse the message given by it." Okay, but they don't have any. The town of Dickinson doesn't have any policy regarding putting displays other than signs.
Right.
The town of Dickinson has a display for, but they don't have any policies regarding private displays, unattended displays in the public square.
Mm-hmm.
So, is there a right for it to remain there forever?
Well, here's the thing. It says person who comes into control. Listen to this portion of it.
Okay.
Person who comes into control of property of another that he knows to have been lost, mislaid, or delivered under mistake or as a nature of amount of property, with intent to deprive the owner thereof, fails to take reasonable measures to restore the property to a person entitled to have it. Okay.
All right.
So I would think that you could box it all up.
Okay.
Put it in a storage unit, and send a letter to the township and leave a note at the location and say, I found this stuff. It looks like it could have been destroyed. It probably belongs to somebody. I don't know if it's abandoned yet or not, but if anybody wants to claim it, I will store it for 90 days and make it reasonably available to you. So therefore, you don't have the intent to deprive the owner of their ownership interest in it.
Right.
And the statute says you can take control of the item. In fact, that makes sense. We don't want you to see a gold coin on the side of the road and just kick it in the ditch.
Right.
We want you to return it to its owner to get it back to its highest and best value.
Right.
How's that sound?
So in other words, you can take control over it. You maybe put a little posting up. Maybe even tell, or should you take it if the town has like a lost and found department?
Yeah.
Offer it to the lost and found.
I take it right to the police department and say, "This is what I found. Here's a box of stuff I found in the public square."
Right. Okay. Well, that's real interesting, Carl. Thank you very much for that. That will be some good guidance that we will take into serious consideration.
All right. Good luck.
Take care.
All right. I think I know what that was all about. So read between the lines on that one. There's another guy named Carl with horns. I think that's who that was. 540-0580. But I think he's on to something. I see what's going on here. Kelly, you're on the air. Just give us your question, and we're going to come back and answer it.
Yes, sir. Going through a divorce, getting towards the end of it, and we come up with a property settlement agreement.
All right.
And with the equity in the home, and we were waiting on the appraisal. The other attorney threatens us to take us to the divorce master.
While you're waiting for the appraisal.
Yes, sir. And my attorney, apparently, this is a game of poker, my attorney capitulated and said, "Oh, you got to sign this because if you go to the divorce master, it's going to get a lot worse, blah, blah, blah."
All right, hold on. We're going to talk more about it after the break.
Okay.
540-0580. See you guys after the break. Well, you all know what that was about, right? That was the Pennsylvania Non-Believer Society, probably president, if I had to guess right. This is Prince. I love Prince. Or formerly known as. Yeah, good stuff. He's a musical genius, by the way. Literally can play every instrument. Little Red Corvette's another one of my favorites. Anywho. Yeah. So that was the atheist. So what they're trying to figure out how to do is pack those evil nativity scenes up off the public square. And what they're running into, I guarantee you, this is the scenario. I think he didn't come out and say it, but the township goes, "Oh, we don't know where that came from. We didn't put it out there." Well, if they're not going to claim ownership of it, and they don't know where it came from, and they don't know who it belongs to, then I think my friend is right. It falls under the mislaid or abandoned property, but might be just lost, might be just mislaid, might belong to somebody. And the township's not going to clean it up. But I think he can take control of it and hand it to the police department. Now, the interesting thing is, right, once he hands it to the police department and somebody comes and claims it, I don't think the township can any longer say, "We don't know who it belongs to." So it's a little game of cat and mouse. And, if the townships want to call in and get some free advice here on the air, I'd be happy to help them too. But anyhow, that was pretty funny. So Kelly, anyhow, back to your divorce, away from high religious politics here for a minute, and back to your divorce. So you signed the agreement or didn't sign the agreement?
Well, my attorney insisted that I sign the agreement because I had my home appraised 2 years ago, and it appraised for $160,000.
Right.
For the divorce settlement. Now, I just had it appraised last week, and it was appraised at $130,000.
Okay.
Now, all I'm trying to do is stay in my home and keep my children in the only home they've ever known.
Mm-hmm.
Under duress, my attorney insisted that I sign this agreement before the appraisal came back.
Well, that might be malpractice on your attorney's part.
Because he was like, oh my God, you don't want to go to the divorce master. You're going to get, so I signed it.
So
now I got to go out of I have to sell my home.
And here's my question for you. Was there a master's hearing already scheduled?
No.
So we're just going to press it before it? You could have waited a few more days for the appraisal to come back. That doesn't sound like good legal advice to me, but I don't know. I wasn't there. I don't have all the facts. But I would have some concern about that.
I want to refinance the home, and I have enough equity to give her half. So now I have to sell my home, and I signed this agreement under his advice. He insisted, and now what recourse do I have?
Well, your recourse. How long ago did you sign this agreement?
How long ago?
Yeah,
I signed the agreement about 3 weeks ago, and I just got my appraisal back on Tuesday.
Right. The short and long and short of it, you probably can't undo the agreement because you knew you had an appraisal pending at the time you signed it, right?
Correct.
So nothing's really changed. Your only thing would be to go against your lawyer and say, you had me sign this, and here's the consequence, maybe of a malpractice claim. But again, I'd have to know a little bit more about the particulars and all the correspondence and discussions you guys had at the time. It sounds like you got classically bad advice.
I know I got bad advice. That's why I'm asking, what can I do? Because all I'm trying to do is keep my home and keep my kids in their home.
You understand that. I'm trying to say is that once you sign the agreement, between you and your wife, that's your agreement. Whether you got bad advice or not, that's a separate cause of action against your attorney. Unless there was some fraud in the creation of the agreement by the other side, then that would be grounds to open it.
So that document I signed is legally binding, and I have no way out of it. Correct?
Well, wait a minute. That's not what I said. I said if you could show some fraud, maybe yes. But general rule, no. I mean, it goes back to the governor now complaining about the Penn State thing. They entered into an agreement. Once you have an agreement, you have an agreement, and the time to fight it is to go to court. And your lawyer sounds like, and this is a question I would tell anybody and everybody who's got a divorce attorney. If your divorce attorney has not been to the master a few times, at least, or more than a few times, then they probably aren't really practicing appropriate divorce law because you can't work every case out. It's impossible. I
think this gentleman is a general practitioner. I don't think that's his forte,
right.
Divorce.
And that would be my only concern because in my experience, I'm not afraid to go to the master. More importantly, going to the master just means filing some paperwork, and most masters in most counties, the first thing they do is a settlement conference. So your appraisal would have been back, and we'd be ready for a settlement. So right. I don't see how that was good advice. But I don't have all the facts. I got to put that caveat there, right?
Right.
I mean, maybe there's some other secret you and your lawyer are sitting on. Maybe you don't even realize it. That would have been something that would have come out at the Masters, which would have changed the way things played out to your detriment anyhow. I don't know. Maybe, I'll give you an example. Let's suppose the other side's completely misvaluing something, right?
Right.
And you want to fight over $10,000 or $12,000 or $15,000 or whatever, and I'm going, but the other side's off by $30,000 on the other thing, and they're going to see the light or are very likely to see the light. It might be good strategic advice to say avoid a fight lest they figure out their mistake. See what I mean? So there are times when what would be seemingly bad advice is actually good advice.
Okay, well, this attorney told me I signed the agreement, and that's it. It's a done deal. and I have no way out of this.
Probably not. I would encourage you, you want to pay some more money, you can have somebody read everything over, take a look at it and see. But I didn't tell you there's no way out. I told you if there was fraud on the other side, that's always a way to reopen these things. But there probably wasn't likely that. And you may have a lawsuit against your attorney for malpractice, for giving you terrible advice, but we'd have to know exactly what you knew and what you knew when and why. But I am telling you that I just see it doesn't sound like that was great advice. If the appraisal's about to come in, you write a letter to the other attorney. It says, hey, Chuck, we're 2 weeks away from an appraisal. It would be malpractice for me to advise my client to sign your agreement until we know what the appraised value is. So if you have a problem with it, file for the darn master and we'll deal with it.
Right. Well, like I said, the only analogy I can give you is a poker hand with a big pot, and he called his bluff and he folded. And I...
and here's the thing. Here's the thing. It really... The hand isn't live yet, because even if he files a presby for the master, the whole thing can still be settled in 13 seconds. I'd have told him, go ahead and file the presby for the master so you have it. And we'll sign the agreement if the appraisal comes back adequately. Otherwise, we'll fight you. That's the right response, I think, based on what you've told me, okay? Unfortunately, you didn't get the right response.
No.
Doesn't sound like it, based on what you told me.
Right. And there's, to my understanding, I'm a layman, that's cut and dry.
Yeah.
I mean, so...
I hear this, I get this sometimes, I see other attorneys do this, and it's not I see every attorney doing it, but I see other attorneys do this. They get involved in divorces, but they don't want to go to a master's hearing. Well, you know what? You have to be prepared to do the master's hearings. You can't settle every case, just the way it is. Or they get into custody cases and they force their clients to take these cockamamie custody settlements at conciliation and have almost no custody trials or no custody trials. Now, you can't practice custody for 10 years and never have a custody trial. Otherwise, you've been so lucky that every case can work out, or you've always gotten the client who should have lost. Or maybe you're just not taking the cases you could win forward, and that's always my suspicion when people don't have a lot of litigation experience. Now, it doesn't mean you litigate every case. Custody cases, I probably 6 or 7 out of 10 don't go any farther than conciliation.
Okay.
But there's a few that need to go farther, and it's the same with divorces.
At this point, I live in York County.
Uh-huh.
Who do I need to contact about this to try to get this rectified or...
Well, I think you're going to have another attorney look over the agreement and try to figure out whether or not it was strategically wise to sign it, and then figure out what your damages are. But it sounds like more like you have a professional malpractice claim than an ability to open it. But if you contact me off the air, I'll give you some referrals, okay?
Well, like most people, I'm pretty much tapped out with child support and everything else, and it's.
I know. Contact me off the air, and I'll get you some referrals to people to talk to, okay?
All right. Thank you, sir.
All right, brother. Oh, I hate when that happens. That's one of those ones where, maybe he's not giving us all the information. Maybe his attorney, if you wrote him a letter, would write you back and say, strategically, here's what happened. Here's why I did what I did. Here's the whole enchilada. And this guy's just off his rocker crazy. And that's possible. But it's also, and like I said, I've seen it before where people just are like, well, it's a master's hearing. You don't want to go that route. But if you're literally waiting on an appraisal, if the appraisal's already been ordered and whatnot, and the other practitioner on the other side has half a brain, they're going to wait for it anyhow, unless they knew it was going to come in poor and they were just sort of rattling their saber, hoping the other side would fold. I got to go to break. We can speculate about his case later. Welcome back. Carl Rominger here, 540-0580. Shane, who's on line one? There's no name on that. I'm going to be like, it's like Bob Durgan's here. It's just ruining the machines. Luke.
Yes.
Luke, I am your father.
Yeah, that's the first time I heard that.
I bet.
Got a little question here. With the beginning of the year here, that the girl that had gotten shot on New Year's Day from, I think it was down in Jersey or Delaware or something like that. Me and my wife were sitting around the house talking about it. We heard it on the TV, and, I'm a gun owner and stuff. And, there's a lot, everybody, it seems like, likes to go out and shoot their guns on New Year's Eve, we got to talking, what happens when the police start their investigation and they start, okay, well, this is the angle the bullet come from, so they kind of, extrapolate out how far it goes, and then start knocking door to door, hey, was your neighbor shooting? And, and then, oh, yeah, well, so-and-so was. So they come knock on your door and say, hey, we want to, we want your gun to, we want any guns you have so we can do ballistics tests and stuff, because the way I had understood on the news report, they're looking to press charges, which obviously, reckless discharge of firearms or whatever, it's not safe, backstop and stuff. So, our question is, what point, where do we stand as a gun owner to say, well, yeah, I shot my gun, or not even admit that, but, what right do you have to take my gun to test it? Do they have to have a search warrant?
Yeah, let me start you right from scratch, okay? Knock, knock. Yeah, well, who's there? Police? Oh, okay. What do you want? Oh, we want to talk to you about a shooting. Okay. What do you want to know? Well, we wondered if you were out on New Year's Eve. Well, listen, officer, it's been nice talking with you, but I don't really want to talk to you guys. Well, do you own any guns? Well, I don't know, officer. I don't really want to talk to you. I have this Fifth Amendment right of silence, and I'm going to exercise it. So maybe you guys go knock on my neighbor's door. Oh, well, it's very important you answer our questions, because we can do this the hard way or we can do this the easy way. Well, officer, if you're not going to honor my Fifth Amendment right to remain silent, perhaps you'll honor my Sixth Amendment right to counsel. So when my lawyer gets here, you can talk to him or her. Okay?
Okay.
All right. See you later, buddy. Bye. Goodbye. Don't hurt yourself climbing in the car. Drive safe. Protect and serve. Is that what it says? Oh. That, my friend, is your response.
Okay.
Now, if they subpoena you to a grand jury, right? You have to answer the questions in front of the grand jury. Okay?
Uh-huh.
But even then, you should have a lawyer with you, and your lawyer is going to work out either a proffer where you can say, yeah, I was out on New Year's, here's where I was, and by the way, I didn't shoot a gun, and then they leave you alone. Or maybe you were the guy who shot a gun on New Year's Eve in the vicinity, and then you better be doing all the things I'm telling you times 3, because it might have been your gun, and there's no sense getting yourself in trouble unless you feel guilty and want to turn yourself in. Maybe that's the right thing to do. But my point is, yeah, and by the way, the government's going to probably keep ballistics on every one of your guns that they borrow, right?
Uh-huh.
So make them get a warrant. Worst thing you can do is just tell them, no, I'm not going to cooperate. And my favorite is you can't get a warrant because the guy won't cooperate. I've seen the police try this. We tried to ask questions, and he remained silent, refused to answer our questions, which makes us suspicious. Well, that doesn't work because the exercise of the Fifth Amendment right to remain silent is not a basis on which you can make suspicion. Okay? Mm-hmm. Legally. Okay. It might make the officer suspicious, right?
Yeah.
But it's not a way to legally become suspicious. So that's the answer.
That's about what I told my wife. I said, not that we did anything like that, but I said, if anybody ever comes to the door, police or FBI, whatever, it's like, no thank you. We don't wish to talk to you, and we're going to call Carl, and Carl can deal with them.
Damn it, woman, don't let him in the house.
Right.
Yeah, okay. No, that's also my other little joke, by the way, though, about all the underage parties that get busted at the universities around here. It all starts with a drunk student at the door letting the police in because you don't have to let him in, and nobody was ever going to get busted. But the kid's like, half officer, oh, hi, officer, come on in. And the police officers always tell me, they're not out trying to – remember this, the police are not out trying to violate people's rights. So if anybody ever gets the idea I think that's the case, the answer is no. And I've had a couple of officers tell me that like up in Shippensburg, you just go door to door, you listen for loud music, you knock on the door, and some of the places, nobody lets you in. And some of the places the guys let you in, and then you bust the underage drinkers. And they're like, we don't have to violate anybody's rights. We can just count on the next house to open the door.
And just let you walk in.
And that's the thing with your neighbor. You can say no, and they'll go to the neighbor, and the neighbor will hand over all 14 of his guns because he thinks he has to.
Right.
And I go mentally insane because I sit down with people. I already am mentally insane, but I sit down with people, and they say, well, I didn't know I didn't have to talk to the police. I'm like, do you watch TV? Well, yeah, I do. You have the right to remain silent? I've heard that. And anything you say can and will be used against you quite a lot? Yeah. Well, what do you think? That was the fictional part of the show? I mean, that was. Don't you know the aliens and the monsters are the fictional part?
I think that most people would think, well, I don't. It comes to the point when once I'm in handcuffs, then I don't have to talk to the police. But like you're bringing a good point. It sounds like that even before the handcuffs come out, when they're just asking questions, is when you might not want to answer questions as well.
You know, when you get those, and I'm not going to single out any particular religion, but when you get those religious people at your door, you know, who want to hand you some tracts, and you push them away and you close the door, or you get the sales guy at the door who wants to sell you insurance and he's trying to wedge his foot in the screen door before you can close it. That's how you should treat the police when they're at your house. And I don't mean it because the police are there to do anything bad, but if they're there for no big deal, that's fine. They can tell you why they're there and what they need to know, keeping in mind, by the way, they can lie to you. But there's no need to admit them into your house. There's no need to admit the government into your house ever, unless they have a warrant, and then you have to let them in, but then you can challenge the grounds for the warrant. So I don't counsel a breach of the peace, but I do counsel keeping your interactions with government to a minimum for two reasons. One is, A, you never know what they're up to, and B, government needs to learn to do its job without expecting citizens to bend over backwards and give up their rights left and right. That's my theory, anyhow.
Okay, well, just another tidbit for you.
Yeah.
I just went in yesterday. January 1st, I went to Cabela's and purchased my first handgun.
Yeah.
And I went into the Cumberland County Courthouse yesterday to drop off my application. There was a stack of applications for concealed carry. It would look like it was about maybe 8 inches thick, and the lady told me it's about 45-day wait.
So everybody and their brother's getting their permit while they can.
Yeah, that's what it's looking like to me.
They're thinking that the NRA is going to hit 5 million members here pretty short. They've hit 100,000 since Sandy Hook, and they're thinking they're going to hit 5 million here pretty shortly.
Yeah.
So
there's just tidbits there. So.
Yeah, interesting observation. Yeah, that's a big stack there because usually Cumberland County is very prompt, so they usually turn those things over fast.
Well, and I was reading in the gun rights book or whatever, the Pennsylvania, what you have to know. It said about, that the sheriff has 45 days from the time you submit your application. So I told my wife, I was like, well, maybe she was just, given the longest time frame, that they had to turn it back.
Right.
Maybe it'll be a lot quicker turnover.
It may be, but they're probably giving you that because they're looking at it going, ooh, egads.
Yeah. Okay. Well, hey, thanks a lot for your help.
All right, my friend. Take care.
All right. Bye-bye.
540-0580. Dean, you're on the air. Hey, Dean.
Yes, Carl. How you doing?
Good.
Appreciate you taking the call here. I got a quick question for you regarding a property in Lancaster City. It's a second home. It is not, nor has it ever been a rental property, but the city has on a couple occasions sent a notice that it's in violation of not registering as a rental property. So I basically signed the thing that I, was not guilty, sent it in to the magistrate.
Right.
And subsequently they sent another one, and I've not had a date for the first one. This is, in my mind, it's harassment, first of all, but more importantly, they're stating that they want me to sign some kind of an affidavit, and I just don't see the need for that because it's not, nor has it been, a rental property.
Right.
What are your thoughts on that? Why would I be compelled to sign something when it's not the case? It's just not.
So,
I'm not renting it. It's never been a rental property. So what's the deal? Why are they harassing people?
So is there anybody staying in it right now?
Periodically, yeah. Not all the time.
Right, and they're not renters?
Well, it would be me or my friends. Yeah.
Okay, so it's just like a second property.
It's a second home, yeah.
Yeah.
It's none of their damn business, that's what I say.
Yeah, I don't think it is, but I think maybe that's the solution is to explain to them that this is just a second home. I know some people that have a second home that they live in one town and they have a home the next town over because they like to go to the bar and drink and just pass out in their second home.
Yep. Why would I be compelled to sign some kind of an affidavit stating that it's not rental property? It just seems like they're trying to get you in a box or something,
Well, maybe because they want to regulate it like a rental property, but if in lieu of the affidavit they won't regulate it like one, which might make your life easier.
Yeah, but I don't like the idea of signing anything.
Yeah, no.
In other words, if I don't want to say it,
Well, here's the answer. If you sign the affidavit and it's untrue, then they can prosecute you, right? So that's what they're trying to do.
Right. But, I mean, why would I be compelled to sign an affidavit when it's, if they can't prove it in the court of law, then in my mind they can go to hell.
Yeah, I don't disagree with you, my friend. Anyhow, I'll be back next week. Carl Rominger here, 241-6070 throughout the week, 717-241-6070. Look us up at romingerlaw.com. And don't forget to friend me on Facebook for all our exclusive content there as well, including today's exciting pancake recipe. Bye-bye.